Let me ask you a question. What do you do if you want to leave money to someone you care about, but you're worried they'll blow it all in Vegas before the ink even dries on the check? Or worse, what if you want to leave something for your child, but they've got creditors circling around like vultures? That's where the Spendthrift Trust comes in. And in California, it's one of the most powerful tools we have to protect a beneficiary from themselves and from everyone else trying to get a piece of their inheritance. So today, let's break it down. What a Spendthrift Trust is, how it protects your beneficiaries, the exceptions creditors can still use to get in, and some practical tips if you're thinking about setting one up. Be sure to hit the like button, subscribe, and without further ado, let's dive in. So what is a Spendthrift Trust? In plain English, a Spendthrift Trust is a trust that says beneficiaries cannot sell, assign, or pledge their interests, and creditors can't touch it until it's actually in their hands. This means if your beneficiary racks up some gambling debts, goes through a messy divorce, or even files bankruptcy, the assets in the trust aren't automatically up for grabs. The trustee controls when and how distributions are made. So until money is actually paid out, it's shielded. California law backs this up under the probate code, specifically sections 15300 and onward. Here's the gist. Creditors cannot reach trust assets before distribution. Beneficiaries cannot voluntarily assign their interest, and if the trustee has discretion about whether to make a distribution, the beneficiary does not even have a guaranteed right to demand one in the first place. And that last point, that's key. A fully discretionary Spendthrift Trust is like a fortress. Of course, nothing in law is bulletproof. California carves out some exceptions. Child support and spousal support claims can break through. Some public obligations, like restitution and government debts, think taxes, may also get in. And here's the big one. Once money is actually distributed, creditors can usually step in and grab it. On top of that, general creditors with judgments can sometimes reach up to 25% of distributions, though the court has to leave enough for the beneficiary's support. And if you try to create a Spendthrift Trust for yourself, you can forget about it, at least in California. California does not allow self-settled trusts for asset protection. Some states do, California, not one of them. So then the question becomes, when do we use Spendthrift Trusts? Well, some examples are when a child or grandchild is financially irresponsible, when a beneficiary is in a high-risk profession that maybe invites lawsuits, or perhaps to shield family wealth from divorces, bankruptcies, and just plain bad decisions. You can add guardrails like HEMS clauses, health, education, maintenance, and support, or give your trustee full discretion. The more discretion, the stronger the protection. So let's expand on that. When I bring up a HEMS clause, what I'm getting at is giving the trustee discretion on when, how, and for what they can make a distribution for. HEMS being a very common provision, as it does provide some guidance to the trustee. Distributions or use of trust funds for health, education, maintenance, or support expenses. But we don't bog the trustee down with an overly complicated analysis on what qualifies as a valid reason. Contrast this with no discretion and unlimited discretion. In a case with no discretion, we're laying down strict guidelines on when and how distributions are to be made. So, for example, $5,000 each month until all the money is gone, or money can only be used to buy the beneficiary a house or provide them a down payment, and the remainder is only distributed at age 30. The point is that these are cases where we are not leaving the trustee with much room to make a discretionary call, intentionally so. We have a set plan for our assets in our beneficiary, and we simply want our trustee to carry it out. In a case where we have unlimited discretion, we're going to be much more relaxed with our language. For example, we require money to be held in trust for the benefit of a beneficiary and give our trustee sole and absolute discretion to determine distributions to or payments on behalf of a beneficiary as they see fit. Generally, we'll also have an end date in mind, for example, say age 30. But there are cases where we've simply required the money to remain in trust gave the trustee sole discretion to determine distributions, and then otherwise only allowed for the distribution of the remainder after our first beneficiary has passed away. For example, hold money in trust for our son, managed by our daughter, but if son passes away and there are still funds left over, then distribute whatever is left to all of our grandchildren. The point is that where we give the trustee more discretion to determine when, how, and for what purpose to make distributions, we eliminate the possible cases where a creditor of the beneficiary may be able to insert themselves into the line of succession, so to speak. If the trustee has broad discretion and elects not to exercise it, thus withholding distributions for a time, then so be it. The creditor is out of luck, except in particular circumstances as we've already discussed. But remember, choosing the right trustee is critical. Don't hand the keys to the person you're trying to protect them from. As in, don't make your son the sole trustee of money the trust says he's not allowed to dip into. A court would likely allow a creditor to pierce right through that and into that trust in a heartbeat. So here's the takeaway. A spendthrift trust can keep your hard-earned assets safe long after you've gone, but only if the trust is drafted carefully. The right wording, the right trustee, and a clear understanding of California's exceptions can make all the difference. If you have questions about setting one up or you're worried about protecting your kids' inheritance, this is one of those times where a DIY template is 100%, it's just not going to cut it. Talk to someone who drafts these things day in and day out. And if you're not sure who to pick as your trustee, then I've got a whole video where I discuss how to pick the right person for the job. It could probably use with some updating, but the information itself is still good. At the end of the day, go with your gut. You know your kids, you know your family. I have generally found that people's gut instincts on who to pick has been right way more of the time than it's been wrong. However, that's it for today's crash course on Spendthrift Trusts in California. If you found this helpful, hit the like button, subscribe for more, and drop your questions down in the comments below. I do actually read all of those. I'm attorney Andrew Bethel, and I'll see you at our next meeting.